Hey, welcome everyone. And listen, I think before I get going, let me just talk about a couple of things. So um, uh, hopefully you've all used Zoom before, but what you can do is you can go to chat and feel free to ask me any questions. Here, I'm going to go to chat right now. Ask any questions in chat. That's a good way to do that. And also what you can do is if you want, if you have a private question, you can email me at this email address. I'll send it, and I'll be checking that periodically. So if I'm looking at my phone, it's not that I'm trying to ignore you, but here, speaking of which, turn my phone off. But I'm trying to, I'm just going to want to, check if there are some messages or something. So here, let's actually, hold my calls, good. So let's jump right into it. Okay, I'll just wait for questions and otherwise I'll jump into it here. So the thing today, what I was going to talk about is how to, basically how to strategize for a divorce. And yes, it makes me sound like kind of a bad person maybe. So I apologize for that. But listen, what I'm talking about today is perfectly legal. I'm not talking about hiding money or hiring a hitman or anything like that. So it's just perfectly legal things that you can do, and so we'll just get right into it. So the first thing here, let me share my screen again. Sharing, and I apologize. I need to probably here. I need to get an assistant to help me with with these things. But so first of all, the one thing I was going to talk about was Ray Kroc. And did any of you see the movie The Founder? Steve, did you see that movie? Oh, okay. Actually, it's a really good movie. It's about Ray Kroc and how he started. Oh, here we go, another participant. Somehow I have, oops. Okay, we have Larry and Barbara. Hey, Barbara. Hey, Barbara. And again, no offense to everyone or to anyone. I'm going to mute everyone just because otherwise it can get kind of like a cacophony, too much noise. Hi. Sorry, I'm waving to you, Barbara. Okay. Okay, so let's see, we're gonna, and somehow I have a setting wrong, so I have to invite people in. So anyway, okay, here, we're gonna turn that off. Okay, so I was just gonna jump right into it. One thing, if you want to go to the chat feature, if you have any questions, feel free to ask questions, or you can raise a hand too. Oh, here we go, more participants. And yes, I need to figure out how to use Zoom. Okay, here we go. Okay, here we go. So he's in, okay. Anyway, I'll apparently have to keep doing that. Okay, let's just jump into this. So I was gonna, one thing was talk about Ray Kroc. There's a movie, The Founder. I love that movie. One of the things in it, he gets divorced from his first wife, and he insists on keeping his business. And what he was doing is, this is nothing that you need my help with, or that anyone needs my help with per se. I'm just kind of cluing you in on just something, I guess, from a lawyer's standpoint. So, so what he did at a time when his business, when McDonald's was valued low because he probably had a lot of liabilities and whatnot, that's when he went ahead and got his divorce. And so his wife ended up keeping the house, and he got the business. And it worked out at the time. Apparently it worked out financially because the court approved it. And just what I wanted to mention is that for any business owners there, or business owners here, a business is an asset, or it should be properly done. It's an asset because it produces income, and a house is a liability because a house just eats money. All you have to do is pay for insurance and upkeep and everything, but the business actually produces money. So it's a better long-term investment having a business. Sure, we all like to have houses because it's more pleasant than sleeping in a car, and there's some other advantages also. But a business as a long-term investment is a better bet. So basically, yeah, that's basically what I wanted to just clue you in about. So that was a winning situation. Here, I'm going to stop the share for a second. That was a winning situation. Now, the downside is when you don't prepare well. I had a client probably about 10 years ago, and I'm not going to tell his name, but he was making about $550,000 a year, and I did an asset protection plan. I did some planning for him, and then he ended up getting a divorce, and I guess it really ruined him, I guess, emotionally. And I hate to say this, I don't know how to sugarcoat this, but he actually ended up committing suicide. I think just from the stress of, because he had just created this wonderful business, and then he got a divorce and he lost half of it. And for, I mean, obviously that's, he had some other issues going on as well, but that's kind of I just get that as an example that it can be very demoralizing to build up a business or to build up a career and then lose half of it because of a divorce. And actually it got even worse than that, because he set things up in such a way where he trusted the wrong family member, and he refused to put a check and balance in place that I would have always insisted on, and being able to remove his parent as being the trustees anyway. So his parent actually ended up absconding with the money afterwards. The whole thing is just a disaster. But the whole reason I'm saying that is it's really important to set things up properly. And right now, I mean, unfortunately, we're all struggling with this pandemic and all that kind of stuff. But I mean, I guess as long as things are kind of down, as long as business is down, you can have the business evaluated right now for purposes of the divorce. So that's, I won't keep going on and on about that. But and again, let me know if you have questions. You can enter it into chat. If you're on the phone, I think it's *9 or I think it's *9 to ask a question. Anyway, or you can shoot me an email at paul@magellanlawfirm.com, and I'll keep checking my emails periodically here. So let's see. Let me keep going. And this is actually a really cool thing I want to make sure that you see. Oops, I need to share my screen. Share screen. Oops, okay, here we go. So, okay, this is a lot of information, but let me just kind of walk you through this. I have about maybe 5 screens here that I wanted to go through, and this is just kind of to give you an idea to what your appetite about what's possible when it comes to protecting assets. So what you can do, a very, very typical traditional way of protecting assets is to create a limited partnership, a family limited partnership, and have, let's see, I guess not everyone has their screen shared, but Stephen or Barbara have family limited partnerships, right? Oh, okay, well, let me just kind of explain it. So what it is, think of it like a family holding company. So it's this business entity that you hold within the family, and you can put your investments and whatnot in it. And there's a lot of advantages. One of the advantages is it's protected from creditors, because it's you would own only maybe 1%, or you and your spouse could own, each own 1%. And the other 99 or 98% is actually outside of your ownership. It's outside of your name. So the one rule when it comes to asset protection is what you own can be taken from you, and what you don't own can't be taken from you. So the idea here is to take things outside of your name. And here, let's see if hopefully you can see this cursor, my cursor here. So this little red triangle, it's an asset vault trust. It's a special kind of a trust where whatever is owned in this is outside your name, and it can't be, literally it can't be taken from you. Like if you get sued, it's not one of your assets, so you don't even have to list it. If you get a divorce, it's not a marital asset. If you get a payroll protection package loan, and it turns out that you messed up and you have to pay it back, it's not forgiven. The government literally can't come back and seize anything in this asset vault trust because it's not in your name. It's like you gave the money to the church or to a synagogue or charitable organization. The IRS or the government can't go back to the charitable organization and get something you gave because you gave it. And I'm assuming that you did it at a time where it's proper, and you weren't already on notice that the government was coming after you. Okay, so there are some parameters here. You can't just do it any old time. But anyway, so this is basically it. So there's a lot of boxes here and information. Let me know. I could send this to you if you're interested. But basically, so you're the happy face. You own 1% of a general partner of a limited partnership. And that, again, it's just a business entity. Being a general partner just means that you control it. But you only own a 1% interest in it. So you don't own the whole thing. The 99% can't be taken away from you because you don't own it, just like you don't own the Brooklyn Bridge. So creditors can't take that away from you either. So so the trust here owns a 99% limited partnership interest, so it doesn't manage anything. It has no right to control it or to change it or to sell it or any of that kind of stuff. So you can, the cool thing here, oh, another participant. What's going on? Okay, a little chat. And I think I have to, well, I'll go to that in a second. Okay, cool. Thanks, Steve. So the thing about I need to go back here. The thing about this asset vault trust, or the 99% interest here, so you can name your sister or your mom or dad to be in control of this trust, because they can't, even if your sister has a gambling habit, or your dad's a I don't know, an alcoholic, or bad with money or something, they can't do anything, because it just like owning stock. If you own stock in IBM, you can't pledge the stock in IBM or anything, because you don't control IBM. So yeah, let's see here. Oh, here, sorry, Selena, I'm gonna mute. No offense, no offense. There we go. So okay, again, let me know if you have questions, and I will try to go to the next one. Here we go. Okay, so very typical situation for anyone who owns a business. You probably own it in your own personal name, or maybe if you're a little bit fancy, maybe your living trust owns your business. That's another common thing. Anyway, so you're the smiley face. You have your own business here. And let me just kind of explain how you can set things up so that the future growth is outside your name. And this is specifically, the presentation today is about divorces. So yeah, if you get divorced, right now, and then that that any spousal maintenance or child support is based on their current situation, and also based on um, future growth, or future ability to pay. There's been situations where like a spouse or an ex-spouse can go back and maybe ask for more maintenance because the business is doing better or something like that. So I just wanted to show you kind of sneaky things, I guess, that you can do to avoid that situation. So one thing you can do is have a management company, this little extra thing. And so the management company can maybe enter into a contract to manage your business, manage payroll, manage different things for a fee, 5,000, 10,000 a month, whatever it is. So that's just a way that you can slowly get some money into the business, especially a business that's doing really well cash-wise. And other things that you can do is, if the business eventually buys an office building, maybe that's outside of your own personal name, or future equipment can be purchased outside of your name. There's also something called captive insurance. So instead of your own, instead of the business paying for liability insurance, the business can actually own or have an interest in can create this private insurance company. And that's for companies that are really getting a lot of cash flow. Like the cutoff, kind of generally speaking, is maybe 500,000 like extra cash a year is kind of that's kind of the break-even point for when captive insurance works. Anyway, these are just kind of some examples. There are other things you can do, but I'm just kind of giving you an idea of some things that are possible. And one other thing is having a line of credit. So again, you have some investments in this little partnership, and then you can have a line of credit to yourself. Again, you put $500,000 or whatever it is into this partnership, and then the client's question, or your question, is, well, how the hell do I get that out then in the future? Because it's in this partnership. I mean, sure, you control it, but there are rules. You can't just take money out, because that risks a court saying that you're just controlling it and you're treating it like your own personal entity. And then actually, that's one of the reasons that a court could just pierce the veil and disregard this whole thing. So you don't want to just take money out without some kind of a prior understanding. So you could take it out as a loan or a line of credit. And then, because it's a line of credit, it's just like if you get a loan from, so you go to the bank, hey, I need $50,000. Okay, well, the bank is, well, actually, right now the bank would just say no, but assuming that the bank would give the money, the bank would say, well, fine, but we need some kind of collateral. And so the typical thing is to use equity in your home. So there's a HELOC, home equity line of credit. But you could use an expensive car. You could use your interest in an investment account or stocks, or anything, as long as the bank's willing to. And so that's kind of the general idea. And now, typically, they only secure it with one asset, but there's no law that says the lender or the bank, in this case, your family holding company, limited partnership, there's no rule that they limited to only having one item of collateral. So they could actually insist on securing this line of credit. Let's say you have $500,000 line of credit, and they secure that with your house. Let's say you still have your house in your name, your personal bank accounts, and your interest in your business. So that's actually that's a very typical way of securing your business and all your personal assets against, well, especially lawsuits and whatnot. And I forgot about it. Nope, that was it. So I'm going to stop the share and see if we have questions here. Oh, yes, someone asked if the asset vault trust can be done in any state. Yes, it can. Personally, I'm a I'm an Arizona attorney, so I do it in Arizona. There are some advantages from one state to another, but generally, I mean, the general answer is yes. And basically what we're not doing anything that's specific to any particular state. So this is actually different from a, what's it called? Domestic asset protection. I don't know if maybe some of you've heard of like Las Vegas Trust or Alaska Trust. Have any of you heard of that? Anyway, there are special trusts in certain states that offer some protection. It's not the ideal thing, but they do offer some protection. But anyway, the asset vault trust, yes, it can be done in any state. Okay, well, any other questions? Anyone? Here, let's see. I don't know. Do I dare? Can you raise your hand? There's a way of raising your hand. And how do you do that? You do it by, well, there's a way of raising your hand. I think you click on participants. If you're on your computer, you can click on participants, and there's a thing to raise your hand if you want to ask a question, or otherwise, what is it? Okay, here's some questions. Here we go. Can you comment on Ed Bossard's divorce trial that was delayed due to COVID? The media is touting South Dakota as the best state for asset protection. Oh, okay. Great question. And so a question was about South Dakota having a specific law for asset protection trusts. How do I explain this? There are currently 19 states that allow something called an asset protection trust. And the idea is that you can transfer your house or some investments to a trust company in that state, in this case, South Dakota. And then you can remain as the beneficiary. So it does work in some circumstances, but here's the thing: if you get an angry creditor, the creditor can force you into an involuntary bankruptcy. And under the bankruptcy rules, a kind of trust like that, unless it's more than 10 years old, that's considered your personal asset. So it doesn't matter if you have your trust in Alaska or South Dakota or Nevada or whatever. It's called a self-settled spendthrift trust. It's a kind of a trust that specifically in the bankruptcy code is one of your assets unless it's 10 years old. So that's the one thing. And the other thing is if you're sued outside of that state. Now, I don't know in the Ed Borsage case, I don't know if he is a resident of South Dakota, but if that divorce trial or the divorce case is in a different state than South Dakota, I think it's a flip of the coin if the court would enforce South Dakota law. I mean, in Arizona or California or any of the other states that I know about, the state court's going to look at its own statute, and they don't give a crap what South Dakota law is, because it's against the public policy. It's against the stated in the court cases public policy to be able to set up a case like this or set up a trust like this, unless it's specifically set up in South Dakota. So anyway, it's a way to do it. I do something, I called it an asset vault trust, but here, let me type in what it's called. It's a special power of appointment trust. I can't type in, nope, trustee. Okay, and I can't edit it, oh well. Oh, hold on, no, I want to do it to everyone, and I will type it right. There we go. So, okay, let's see. So let's see, is the asset management limited partnership structured the same way as a family limited partnership? Okay, basically, it's a different name for essentially the same thing. And so it's a limited partnership. I'm partial to having it be a limited liability limited partnership. So anyway, and I'm going to go really down a rabbit hole if I try to explain what that is. But there are different versions of limited partnerships, and if they're used privately or within your own family or for yourself personally, it's pretty much all the same. There are differences. I mean, the one thing that I will make sure to add in the language is a lot of restrictions, so that a limited partner, or actually none of the partners, can just transfer their ownership interest to someone without the approval of all of the other partners, because that theoretically is something that a court could do. A court in a divorce or a creditors collection case, the court could theoretically award your interest in the partnership to another party. So we make sure that that can't be done, and it's not technically supposed to be allowed. But let's see, did you hear of intentionally defective grantor trust? Great question. Let me talk about that. So let me share my screen again real quick here. Let's see if I can okay, I'm sharing, and I want to let's see if I can go here. Oh my gosh, I need an assistant. Slideshow, play current slide. Here we go. Nope, without that. Here we go. Okay, this trust here, I call it an asset vault trust. The technical name is special power of appointment trust. And again, that's kind of like, I don't know. I think of like a crossover, and actually a crossover vehicle, like a half SUV, half sedan, or half car. It's called a crossover. There's a lot of different versions of it. You have the Jeep. Oh my gosh, I can't even, my mind's going blank right now, but all the different ones right now. So like each company has their own special model for that. I call the model that I call is asset vault trust, but the actual, instead of like crossover is the type of car, and the type of trust is a special power of appointment trust. In any event, and the reason I use it is that they've been around for over 140 years, and they've withstood the test of time. They've been upheld in every state and federal court, in every possible context, IRS audits, divorces, creditor claims, bankruptcy, government actions, any of those different things. And they just work because it's a very, very standard kind of a trust. So the question was, has to do with, can it be a grantor trust? And yes, the way I always set this up is to be tax neutral. So these things, this partnership, now this has to be taxed as a partnership because it's a partnership. But all that means is you have a separate partnership tax return when you go to do your taxes each year. So it increases the cost by about $300. But in terms of the actual taxes, everything is taxable to you. So this asset vault trust is disregarded. It's a see-through, or a, what do you call it? That's not the right word. Flow-through entity, or it's disregarded in any event. Sorry. And let's see here. So trying to think what else. Oh, here, I'll explain what here, let's go in the screen share. How do I end the screen share? Am I on screen share? Oh, were you watching that, or I wasn't even showing that, was I? Okay, in any event, oh, stop the share. Here we go. Okay, all right. So the thing about the trust, special power of appointment, again, a very nerdy topic. What it basically means is it's a trust that's outside your name, and what we do is we have it so that you can never be the beneficiary, you can never be the trustee. So creditors, it's outside of your name. If you're ever sued or in a divorce or something, and you have to file the affidavit of all your assets, you don't have to disclose this because it's literally not one of your assets. It's literally not yours. But it's like a tank, and it has an escape hatch on the top of it. And so the cool thing about the cool thing about this is you can have your trustee, you can have your trustee transfer the assets back to you at any point. So, or you can there's a third party within the trust, and you can have that person make you a beneficiary. There's a lot of ways that you can change it, but as long as it's just in its original form, I mean, it's bulletproof. It's like a tank. Here, can you comment on, oh, let's see, blah, 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 special power of appointment. Yeah, pass through. Thank you. Pass through. That's what I was thinking of. Thank you. Not see-through. That's it. Okay, let's see. What happens if the trustee dies? Oh, well, so usually in a trust, you have different, typically you would name a successor trustee, but you actually have the power to name a different trustee if you want. And actually so here's the thing with that asset vault trust, there are about 4 things that you can't change. You can never be the trustee, you can never be beneficiary. Your creditors can never be trustee, and your creditors can never be beneficiaries. But other than that, you can actually change anything. You can change who the trustees are, you can change who the beneficiaries are. If at some point down the road you want to have everything transferred to yourself, and your brother who you named as trustee is being a jerk or something, you just remove him and put someone else in place, and that person could actually transfer the assets back to you. Or and there's also a trust protector. Again, I'm getting very nerdy, but there's there are different ways that you can change it. So yeah, tons of flexibility. Here, let's see, what else were we gonna, oh, here, just real quick before I forget, I was gonna talk about some issues with the PPP money, and let me see if I can find this. Here we go. I'm just gonna put a link in the chat. So one of the things about here, I want to copy it. Why can't I copy this? Okay. Here we go. Okay, so there's a link to something I wrote about the Payroll Protection Package program, and just something to be aware of. I'm not going to spend much time on this, but in all likelihood, people who've taken PPP money are going to have to owe some of it back. They're going to have to pay some of it back. I know there's the whole reason people are so excited about getting it, or were so excited about getting it, is that it was promised to be forgiven as long as you spend it on payroll. But there's a lot of other little little conditions and different things. And so generally speaking, if you know anyone who's taken PPP money or that you're talking to, just please remind them to spend only what they need. And if they don't need the money, then have it available to pay back right away. Just so they don't end up getting to the situation where they, they've spent it and they have to pay a bunch of it back. The business is struggling, and they could actually put themselves in a worse situation then. So let's see, I won't spend any more time on that. Again, let me know if there's any questions. Oh, here's something. This life cycle, should a business owner consider setting up this structure? What are the downsides to doing it or having one in place? Okay, thank you, Steve. So in terms of setting this up, I would say right now that we're still in a time during this current economic situation where it's possible to set up something like this and not have it be just outright called a fraudulent transfer. What do I mean by that? Fraudulent transfer is it's under the state law in every state, and there's different little nuances, but basically state law says that if you transfer assets with the actual intent of hindering, delaying, or defrauding creditors, that the court can bring the asset back and use it to pay the creditors. And there's a similar language in the bankruptcy code. So the thing right now, and they have to prove actual intent, but I mean, proving actual intent would be, I mean, right now, if you're totally underwater, you owe a bunch of money to creditors, they're suing you, you've actually been sued, and then you transfer some assets. Well, I mean, the court is going to just infer that you had the actual intent of hiding those assets. For someone who is not being sued, even though you might be scared, justifiably scared about the future, you don't know if everything's going to pick up. Like, I mean, Trump says everything's going to be back to normal by the end of the year. Or, is this going to drag on for a while? Are things going to keep accumulating because, now we had food crisis, food shortages, and I mean, and that's impacting the world economy. And I don't know, some of the, Steve, maybe you can chime in because you know more about like the economics of this, but in any event, it's anyone's guess right now, but kind of I would argue that a lot of people right now are kind of having the assumption that things are going to pick up sometime this year, and it may not be totally normal, but things are going to at least pick up. So based on that, it would be reasonable for you to set something up like this. And you're not, by the way, you're not setting this all up just for protecting yourselves from, from being sued by your creditors and whatnot, if you have personal loan guarantees or, whatever your situation is. It also is done partly for estate planning reasons, and it's done partly for, just basic business organization. I mean, it's a legitimate purpose to segregate things. There's nothing fraudulent about having separate companies. Like, if you remember that slide I showed maybe 20 minutes ago, where you had separate companies, and one company owns the building and one company owns the equipment, things like that. There's nothing fraudulent about that. You're just organizing your business in a certain way, and there's nothing wrong with that. Now, at some point later, as the months go on, if things don't just pick up, kind of like everyone is crossing their fingers about, it gets a little bit more risky, because it's starting to look more like you're trying to hide assets or hinder your creditors and whatnot. So just generally speaking, if you're thinking about doing something, I would tend to say do it sooner than later. Let's see, what downside to doing it or having one in place? Yeah, so that's the downside. The downside of it, the downside is paying an extra $300 a year for a partnership tax return, and frankly, that's about a downside. I mean, you're doing it in such a way that you're not that you're not hiding known creditors, creditors who are literally suing you or something like that. So, you know, if you can do it right, if you can kind of do it before that, and I'm generalizing here, but okay, here's another question. In a divorce, is the other spouse considered a creditor? Okay, actually, let's talk about that. So the other spouse, I wouldn't say creditor yet. After the divorce, let's say the spouse gets a judgment for a property settlement, and it says that you know, part of the equalization, okay, you client got to keep the business, but you owed the um, I don't know, $500,000 as an equalization payment. Yeah, now that, just like someone who sued you for not paying on a loan, that's literally a judgment. Oops, it says the internet connections. Okay, hopefully you can hear me, right? Steve or Barb, can you give me a thumbs up? Okay. Okay, thank you. So something that actually a lot of people don't know about, though, is property settlements can be discharged in bankruptcy, in Chapter 13 bankruptcy. So that's actually something. Yeah, it's this is maybe a little bit sneaky, but I happen to know that if you or a client were able to get a to to keep the business or some asset like that, and then you owed money to the other to the to your ex-spouse, you could literally file Chapter 13 bankruptcy at that point. Now the the business is going to be considered part of it's going to be considered an asset, but Chapter 13 is just where you're paying things back over a period of years, and frankly, the divorce settlement judgment would be one of the debts that can be discharged in that. So you could actually get discharged for pennies on the dollar. Make sure you talk to your divorce lawyer or and probably bankruptcy lawyer before doing this, because but yeah, that's actually possible. So there are some little possibilities like that. Now that's a property settlement agreement. So that would be like an equalization payment in a divorce. It does not apply to child support or spousal maintenance, alimony. Those are not dischargeable. So let's see. Okay, let me keep going on. So how to protect your assets from other liabilities? Well, actually, so if you remember, here, let me go back, share my screen so we can have so I can show my PowerPoint here. Okay, so this is just kind of showing you again, the basic situation where you have the vault, the special trust, and the partnership. This kind of a thing can actually protect you from, again, lawsuits, divorce, IRS audits, government actions. One thing I just wanted to mention, it's kind of crazy. Over the coming little while, I predict that there are going to be new causes of action. And I was just talking to Monica. Monica's on the call here. And she was mentioning a German company that wants to sell face masks, or was considering selling face masks to the US, but apparently they're backing out or backed out because of the risk of being sued. So, I mean, literally probably one of the new causes of action is people getting sick with COVID-19 because you negligently failed to sanitize the surfaces in your business or something like that. And I mean, that's just one example, but who knows what all the different things are going to be in the future. So here, let me tell you one story about a lady who had something set up very similar to this. So you can just kind of see how this works. She and her husband had set up structures very much like this, and they had a business here, business in Arizona. And in the 1990s, the business went under. They had done this with my former law partner, and so the business ended up filing Chapter 11 bankruptcy, and they had personally guaranteed some loans. So pursued and creditors got judgments. But because they enough personal assets for the creditors, and there's actually a line of credit from this partnership to them, secured their own house. And if I remember at the time, it was like a $1 million line of credit, secured by a deed of trust, similar to a mortgage on the house. And oh, here's someone else. Here, hold on. Oh, here we go. Okay, welcome. And again, no offense to everyone. I'm gonna allow people to unmute yourself if you want to. Here, there we go. Okay, I was just going into giving an example of how this actually plays out. So you have a limited partnership here with a line of credit on your personal assets, and I'm sorry, I'll catch you up real super fast. So there's a lady who came to me around 2005, and she and her husband had owned a sporting goods store here in Arizona, and the business went under in the 1990s. Business filed bankruptcy. Creditors sued her and her husband, got judgments, and so the judgments were maybe about $3.5 million. And then, but the creditors never actually collected on anything because they couldn't. The reason was that there was this prior secured line of credit on the house, on their personal bank accounts, and other assets were actually in this partnership, and there's no judgment against the partnership, so they couldn't go after that. Then in 2005, she came to me. Her husband had died in the meanwhile, and she wanted to be able to sell her house and move closer to her kids. Her kids lived, she wanted to move closer to her son and grandchildren, and they lived in Tempe. So normally, if you have $3.5 million of judgment liens against you, recorded liens, and you go to sell your house, well, those get paid first. That's just the way it works. But the rule is that first in time right. So the first, a prior lien gets paid before after coming liens. The house was worth $750,000. There is a $1 million line of credit and deed of trust against the house. So what we did is we had this partnership we had her partnership foreclose on her house, and so then moved the house into the partnership, and then the partnership sold the house and bought a new house that it leased to her. So she ended up getting the same thing. She was, even with the $3.5 million in judgments, she was able to, still be able to move, live the rest of her life close to her grandchildren, and the creditors couldn't do anything. So that's just an example of how it works. Now, not everyone is like that, unfortunately. I mean, I've gotten calls before from people who were interested. Here, I can stop this screen share. Yeah, I've gotten calls from people who are kind of, testing about this, not really sure. And I had a doctor a number of years ago who was kind of not sure, and then it ended up getting sued. And I mean, at that point, then it's too late. I mean, you can't protect your assets from that lawsuit. You can going forward, but so that's, yeah, that wasn't a good situation. So okay, that's actually it. I can answer any questions, or let's see, do we have anything else here? Okay. Well, yeah. So there you go. So that's basically how you protect yourself. And once you put this in place, you cannot be wiped out. And that's actually, I mean, who thinks that's a pretty awesome thing? Like you can literally set yourself up so your life savings. Yeah, cool. Yeah, you can't get wiped out. I mean, you can get wiped out from the economy, I suppose, but you're not going to get sued or the government coming after you or, you know, something like that. I mean, it's kind of freaking awesome, actually. So, listen, let's see, who all here is business owners? Let me spend another 5 minutes, okay? And then we'll close. But let me go into this. So if any of you are business owners or do anything about related to marketing, let me just kind of teach you something. So what I have found is, or I believe, and I've some other smarter person came up with this, not me, but that people's main concerns are time, money, and reputation. And if you think about it now, like what are the top concerns that people have? You know, obviously, what, hand sanitizer, you know, toilet paper, face masks. Where do you get the face mask? You know, can you go to the grocery store safely? Getting enough food. Am I going to run out of bologna? I mean, the crazy stuff that's you know, gone from the shelves in the grocery store. Like I mean, I would have no zombie movie or you know, none of the movies predicted like all the silly things that, you know, that we're facing with reality right now. But I mean, that's actually a proof of people just being concerned about time. You know, how much time do we have on this earth? So the reason I just mentioned that is, you know, how much is your how much time would it take to put something like this together? I mean, I've literally spent 10 years researching this. I've been practicing law about 20 years. So I would just suggest to you that it's really worth it. If you think that this is worth it, then you know, figure out what your choices are. Are you going to research this yourself, or, you know, is it worth it to get someone else to help you? And then, I mean, the other thing is your money. How much money do you have at stake? Think about that. And is it worth investing a little bit, a fraction of what you have, just to protect yourself in the future? And then the other thing is just your self-image and confidence. You know, how much more confidence will you have if you know that you know, no matter what happens, riots in the street, government actions, you know, whatever, lawsuits, bankruptcy, any of that kind of stuff, you can't get wiped out. Now, I can't help you out. You'll have to talk to you know, Steve with in terms of making sure you don't get wiped out with your investments or whatnot. But okay, someone's asking, how much was it cost to set this up and in different states? How long does it establish this and transfer the assets? Okay, so the cost, what I would say is that there's no one size fits all. I don't want to. A typical cost for the asset vault trust is $10,000, and then, you know, there are some additional costs on top of that. I mean, to really get everything all totally put together and buttoned up, and, you know, where you're just totally 100% protected, that ends up costing $25,000. And then how long does it take? I mean, it really takes probably, with the transfers and setting things up, realistically, it takes probably about a month and a half before everything is 100% put together. Because there's just time spent in getting the documents signed, and especially right now, because I help people in different parts of the country, you know, relying on the mail and different other things, so, or FedEx or whatever. So there's just some practicalities with that. And what I do, I'm trying to help people out as much as possible. So if money's an issue, there's a possibility of financing it, or, you know, we can. I don't want money to be the issue, because I just think that this is it's really important for people. And so yeah, that's what I have. How long does it take? will the asset of all trust be in Arizona, and can the client live elsewhere? So typically what I do is I have the, let's see, I'm just, hold on. Oh, okay, I was just checking to see if I had a question by email. So typically I make the trust in Arizona. It just says, so it says Arizona law applies. And the only reason that that's relevant is I'm admitted to practice law in Arizona. So I make it an Arizona trust. And then you can always change it. I mean, you have full ability to change it. And if you really don't want it to be in Arizona, I mean, we can have it be in whatever your state is. I just know that Arizona has favorable laws, so I typically do that. But yeah, it's very, very super flexible. So you can change that to wherever you want. And yeah, I have clients all around the country. It doesn't really matter. Let's see. Okay. So yeah, I guess let me know if you have any other questions, and again, feel free to reach out. I think my email, well, you know how to reach me. Oh, here's another question. Will the trust be? Okay, yes, thank you. Thank you, everyone. If we don't have any more questions, there we go. Okay, stay safe, and good. Thanks for joining today. All right, take care.